Hi, I'm Dr. Tom Swisher of the Resolution Center in Howard County, Maryland. I'm an attorney, I'm also a counselor, and I use these two areas to work in mediation for folks usually going through a separation and a divorce. In this segment, I'm going to talk a little bit about some of the common questions that people ask about mediation. Everything we do in the mediation room stays in the mediation room. It won't be used against you later on, and I keep all of my work to myself and confidential. Mediation sessions last about 2 hours, and the average mediation takes between 2 to 3 sessions. Of course, this varies depending on how many issues you might have and how contentious the two parties might be. But by and large, it's 2 to 3 sessions of 2 hours apiece. You will, at the end of mediation, have a legal separation agreement that eventually becomes a court order. And so anytime that you sign a separation agreement or any legal contract, it's wise to get it reviewed by an attorney. About 50% of the folks that go through mediation actually use attorneys, and you want to be mindful about what attorney you pick. There are mediation-friendly attorneys who want to help you reach a solution, and there are litigation-oriented attorneys who some folks are concerned tend to stir things up a bit. So you want to be careful about that. Well, if you have the type of relationship and you're in a situation where you think you can negotiate fairly and openly without a lot of defensiveness with the other party, then sure, that's okay to do. What happens with a lot of folks, though, is they get entrenched in their positions, and they each take a position that later on in mediation is harder to sort of reevaluate. In my work, I do principled negotiation, meaning that in mediation we're talking about the principle or the issue at hand, as opposed to positional negotiation, which a lot of attorneys use, in which people take positions from which they then negotiate. So you want to avoid doing that. If you are going to negotiate before mediation, my recommendation is that you both agree that if you get to a topic that you can agree to, you simply set it aside to bring into the mediation process. If you go to our website, mdsettle.com, you'll see a checklist of issues, of all the possible issues that you could possibly want to address in separation or divorce or mediation. So you might want to check that out. But in general, people talk about their house, they talk about their personal property, their assets, bank accounts, retirement accounts, their debts, certainly topics regarding their children, what the court calls custody and visitation, which, by the way, I try to avoid that terminology a little bit. You know, it was borrowed by the criminal justice system. We put inmates into custody and we give them visitation privileges. And so it has some negative connotations. In mediation, I tend to use words like parenting agreement and the parenting schedule, sort of neutralize some of these things. You'll talk about health insurance, life insurance, college education, quite a number of different issues. And again, if you go to our website, you might be able to find a full list at mdsettle.com. So there are folks that go to an attorney before they enter into mediation, and the attorney drafts up an agreement. They then present that agreement to the other spouse, and they find that the other spouse is a bit resistant to using that agreement. That's about ownership. You know, if two parties work together to create an agreement, they both have equal ownership in it and are more likely to accept it and comply with the terms of it. It's quite natural that if some person is given an agreement drafted up by the other person and their attorney, for them to be hesitant. If you do have an agreement, though, you can certainly bring it into mediation and we can use it as a platform, or you can use it as a reference for the issues that you want to address. Well, in all cases involving children, and that's basically the parenting schedule and the child support, they are always modifiable depending on the best interest of the kids and the circumstances at hand. Otherwise, it's important in mediation to articulate in the agreement if there is an issue that you want to be modifiable, because it is a binding contract that can be enforced if it's not modifiable. So in Maryland, a person can file for an absolute divorce 1 year from the date that they've separated, no longer live in the same house, so long as both parties can say that the separation is voluntary, mutual, and without the hope of reconciliation. In Maryland, if you can't say that, then you have to wait 2 years from the date of your actual separation. So after mediation, you'll have a signed separation agreement, and if it says that the separation is voluntary, mutual, without the hope of reconciliation, which most divorce cases do say, then one of you will file a complaint for an absolute divorce attaching the separation agreement to that complaint. Now, you can get a form complaint from the Circuit Court of Howard County if you're in Howard County, or another county in Maryland, and we have a link to that site on our website, mdsettle.com. Once one party has filed that pleading, called a complaint for an absolute divorce, then the other party files an answer saying that they don't contest, and yes, please turn our separation agreement into a court order. When that happens, you're put on an uncontested track, which means you won't go before a judge, but you will be assigned to an examiner who's really an attorney. You'll go to his or her office, and in 5 or 10 minutes, you'll put on the required testimony in Maryland. Yes, this is my signature on the agreement. Yes, our separation was voluntary and mutual. And yes, we haven't reconciled since our separation. Maryland also requires that you bring a corroborating witness, someone who can testify that you have separated on a certain date and there's been no evidence of reconciliation after that. In that 5 or 10 minute hearing, the examiner will take that testimony and then draft up an order, send it out to a judge, and it'll sit on a judge's desk for a week or so, and a judge will sign the order converting the separation agreement that we've created in mediation into a court order. So I hope that these are useful to you, and I hope you'll feel free to give me a call.